explain why we are all here in New York City under the banner of a Latin word, Praelium. And the story traces, as many things do these days, to a Starbucks, where Professor Federico Ortino, who is here tonight, was having espresso. I'm not too sure what he can tell us with my partner at Three Crowns, Chiann Bao. This was back in 2014, and it was at a Starbucks, I'm told, just off Aldwych Street in London. So Guyton had received his LLM here with Professor Bermann at Columbia, and he was teaching as a visiting lecturer at King's College. So he asked Federico, is there any way that we could combine these two great institutions and perhaps do an annual mock arbitration with the best and the brightest across both sides of the pond and indeed all over the world? Federico supported the idea, and he introduced Guyton to the then new dean of King's College, David Caron. Dean Caron was also supportive of the idea, so the three of them came over to Professor Bermann, who brought his typical boundless energy and enthusiasm, and voila, the Praelium was born. This is the 8th annual Praelium. It has been held annually in London or New York since 2015. We have had some truly wonderful advocates and even more impressive arbitrators. I won't name them for fear of omitting someone. Professor Dean Caron was able to enjoy the first 3 Praelium, but as we all know, we lost him in 2018, at which time the Praelium was rightly renamed in his honor. Some of you may be too young to have known Dean Caron, but those of you who did could just imagine the smile on his face if he could see this room right now. Dean Caron had an exquisitely fine legal mind, yet there was absolutely no pretense about him whatsoever. He was one of the most approachable, warm, generous with his time people in this field, and he has mentored countless of us, and he is deeply missed. Dean Caron was also tall. He had Hollywood good looks. He had a radio voice, and it is so touching to see his elan and spirit continued with the rarefied advocacy that has graced this Praelium over the years. One last question that might be on your minds is, what does Praelium mean? This is what you get when you have a partner who speaks 5 languages and still remembers his Latin. The term Praelium comes from Chiann Bao, and it means trial of strength. It is a fitting word. It is an august word for this institution. I will say, however, how pleased I was that Guyton gained no traction whatsoever when he proposed Praelium as the name of our new firm back in 2014. Three Crowns is no prize either, so perhaps I shouldn't be throwing stones from a glass house. So that is the history. Tonight is the future. We have some truly wonderful arbitrators and advocates. We are chaired tonight by Chiann Bao of the Arbitration Chambers. She is joined by Judge Charlie Brower, former judge of the Iran U.S. Claims Tribunal and now judge ad hoc with the ICJ. We have, of course, Professor Bermann, who is well known to all of you. And they are being advocated to by some of the best we could find: Angeline Welsh of Essex Court Chambers and Doak Bishop of King & Spalding, another one of my mentors. So with that, I welcome you to the David D. Caron 8th Annual Praelium and invite Professor Ortino to discuss the fact pattern.
Thank you, Luke. And thank you, everybody, for coming. I mean, this is certainly an honor and a pleasure to be part of this event and be among so many dear colleagues and friends. So basically, we were the second choice of Guyton. I'll have to go back to him on that. He never told me that. Anyway, the dispute. for those of you that have looked at it and perhaps have followed the Praelium, you will notice that this year, for the first time, the dispute is not between an investor and a state, right? It's a commercial arbitration. This is it's certainly a novelty, and one wonders whether this is just one of the many signs of things to come. Maybe, maybe not. We shall see. Okay, so commercial dispute. It revolves around a failed acquisition by Waystar Royco, a global media and entertainment conglomerate of a majority stake, the acquisition of a majority stake in a rival media company, Pierce Global Media, or PGM. The failure is due to public criticism, which was received by the seller, PGM, following an alleged cover-up of inappropriate conduct by Waystar Royco. So that's sort of the basics. Now, on the details, in order to block a second sale of those shares to a third party, Waystar Royco obtains an interim relief from the High Court in England and subsequently commences arbitration. As per the original shared purchase agreement, which provided for arbitration in New York according to with the ICC rules of arbitration. Now, so that's where we are. Waystar now applies to the arbitral tribunal for permission to apply to the English High Court for a continuation of the English injunction. Now, PGM resists the application, arguing two things. First, the arbitration clause expressly excludes the power of the English court to grant such interim relief. And two, in any event, the application should be rejected on its merits, as defendant has not breached the sale purchase agreement because the cover-up by Waystar Royco is in breach of one of the warranties, which is included in the original agreement. And there's also a small chance that PGM can actually sell its shares to the third party. So that's where we are in the proceedings, and I leave you to this excellent arbitration.
Thank you very much. I understand that the claimants will be presenting first, and this will be represented by counsel Angeline Welsh, please.
Thank you, Ms. Bao. Good evening, members of the tribunal. As you know, Waystar applies to this tribunal for permission to apply to the English court to continue the injunction relief, which is already in force. In short, Waystar paid $250 million as a significant initial payment for a 75% shareholding in PGM. Despite taking Waystar's money, PGM shareholders refused to transfer the shares to Waystar in clear breach of their obligations under the SPA. The truth is that the PGM shareholders, a group of privileged trust fund kids, did a deal with the Malik Group behind the Waystar Group's back. Aaron Malik, a well-known Saudi-based billionaire, who is known to have a personal rivalry with Logan Roy, the principal of Waystar, offered them a deal they did not want to refuse. It may have been a deal the PGM shareholders preferred, but it was not a deal which was open for them to strike. They were already bound by contract to sell those shares to my client. The PGM shareholders rely on a breach of warranty to terminate the SPA on the basis of an unverified newspaper report. This is a straw man argument. It's an excuse dreamt up by their high-powered legal team after the event. But as we shall see, it's not a particularly good one at that. To be fair to Mr. Bishop, he does not have a lot to work with. A change of mind is not a good basis for a breach of contract defence. The English injunction was necessary, Without it, the PGN shareholders would have sold the PGN shares to Malik under the Malik SBA. In granting the injunction, the English court also satisfied that there was a risk of dissipation of the 250 million received by the PGN shareholders from Waystar's money. The reason that we're here today is due to a quirk of the English Arbitration Act, which places certain guardrails around the English court's ability to act once a tribunal is constituted. In particular, in this case, it requires Waystar to apply for permission to this tribunal before making the application for continuation of the injunctive relief to the English court. Members of the tribunal, my submissions will be structured in 3 parts. First, I will take you through the relevant provisions of the English Arbitration Act so that you can orientate yourselves as to the principles applicable to the issues you need to decide. Second, I will address the first issue you need to decide today, namely whether the parties have excluded the powers of the English court to grant interim relief. Third, and finally, I will address the second issue, whether you should, as a matter of discretion, grant permission for the continuation application. I should be clear, I accept we only get to this second issue if the tribunal is with me on the first.
Counsel, I'm very flattered that you seek our permission. Do you need our permission?
Well, so let me take you to show you exactly why I think we do need your permission, and that's by starting with the first area of my submissions, which is the legal framework which applies to this application. Now, members of the tribunal, you will find the relevant legal provision, which is section 44 of the English Arbitration Act, in your pack of papers. It is at the annex of the pack of papers which you have before you. If you can turn to section 44 in particular. So, as you'll see from the heading, section 44 is a provision of the English Arbitration Act which confers powers on the English court to act in support, and that's quite important, in support of an arbitration. It is available in relation to a foreign-seated arbitration proceedings, provided that the fact the arbitration is seated outside the English jurisdiction does not make it inappropriate for the English court to act. That's section 2.3 of the English Arbitration Act. You don't need to look at that for present purposes. The first point to note under section 44 is section 44.1. Tribunal, I'd like you in particular to note the language, the first part of that provision, unless otherwise agreed by the parties. The tribunal can see that. This language has the effect of making section 44 a non-mandatory provision. In other words, the parties can agree to exclude it. That's common between myself and Mr. Bishop. The point taken against me, quite incorrectly I say, is that the arbitration clause between the parties in this instance does exclude section 44, and that goes to the first issue the tribunal needs to decide today. I will come back to this, but in brief, the PGM shareholders in my submission have seized on points of English law to make a construction argument to say that section 44 has been excluded. But that wholly ignores the fact that New York law governs this arbitration clause, and that is determinative of the point. Second, if the tribunal will see section 44.2, this sets out the matters which the English court can give interim relief in relation to. For present purposes, it's section 44.2e, which is the granting of an interim injunction, which is of particular relevance to us. Third, we now come to the guardrails which section 44 places around the English court's ability to act, particularly once a tribunal is constituted. We are not in section 44.3 here because this case is not one of urgency. That is because the English court injunction is in place at the moment, protecting my client. The relevant provision, and this goes to Professor Burnham's question, is section 44.4. If the case is not one of urgency, the court shall only act upon the application of a party to the arbitral proceedings made upon notice to the other parties and to the tribunal, made with the permission of the tribunal or the agreement in writing of the other parties. Now, quite self-evidently here, we don't have the agreement from the PGM shareholders to make the application. That's why we're here before the tribunal today. It's relevant to note that there are no set guidelines in English law as to what will govern the exercise of the tribunal's grant of permission for the purposes of Section 44. The question in my submission is really a balancing act between, on one hand, meeting the merits-based threshold for the English court to grant injunctive relief, which in this case is that the claimant has a good arguable case, and I'll come back to that. And on the other hand, recognising that the body that will ultimately determine the merits of the claim is the tribunal and not the court. In my submission, this balance is achieved by the tribunal asking the question, starting by asking the question, what is the relevant test for the grant of interim relief by the English court? That is good arguable case. And applying that good arguable case test to an assessment of the merits of the dispute in this particular arbitration, which of course is something which is governed by New York law. Now, the English law test, good arguable case, is slightly broader than the merits of the claim test, in that the test as a matter of English law is whether there's a good arguable case for there being granted a judgment or order for the payment of a sum of money that will be enforced through the court process. So it's slightly broader than merits, but for the purposes of my current application, I'm prepared to accept that the question you're concerned with is the merits of my claim.
Excuse me, counsel, if I, could you repeat that? I was going to ask a question. What role does, if any, on this issue, does the chances of success on the overall case play a role?
Yes, the test is whether there's a good whether my claim has a good arguable case of succeeding. So my claim is for the transfer of the shares to Waystar. So the question on the English test, if when you're applying for an interim injunction, is whether I have a good arguable case. Now, as a matter of English law, the test is slightly broader than a merits-based test, because what the court would be asking itself, the English court, is whether you're likely to receive a award in this particular case, which will result in the relief to which the injunction goes to. But for the purposes of the application for the tribunal, I say today that on the facts of this particular case, what you need to ask yourself is there a good arguable case that I will succeed in my claim? And that's the test.
And the High Court will not look at all about the potential merits of the claim against you?
The defense against me.
The defense, yeah.
So I would say that goes to whether or not I'm likely to succeed on my claim. And the interesting question, I think, that you're raising is whether the English court would look at this question afresh. I don't think that there's anything to stop the English court looking at this question afresh, but there's a reason why the legislation provides that a party must apply to the tribunal for permission, and if the tribunal were to grant permission, that would be a significant factor in the court making an assessment as to whether there's a good arguable case, because obviously it is the tribunal who will ultimately decide that merits-based question. There's one.
Excuse me, why
Yes.
why does not the terms of the SPA basically bar you from being in the English courts? I mean, it's basically, it says any dispute arising out of this contract shall be referred to arbitration in New York, obviously subject to New York arbitration law, in accordance with the ICC rules of arbitration. None of the parties here to, nor any persons claiming under any of them, shall bring any action or other legal proceedings against any other of them in respect of any such dispute until such dispute shall first been resolved and determined by the arbitral tribunal.
Well, Judge Brown, that's a question which goes to the first issue. So after I've, yes, that is an issue which is for me to address as in my submissions on the first issue. So I will just complete my submissions on the legal framework, and then I will come back to that. But that's obviously a point which is disputed between me and Mr. Bishop. The final section, just to draw the tribunal's attention to, is section 44.5. And this, on the facts of our case, the relevant provision is that the court will only intervene to grant the interim relief where the tribunal is unable to act effectively. We, of course, accept that the tribunal does have the power to issue interim relief, but we say in this particular case, the tribunal is unable to act effectively. I'll come back to that, but we also say that's primarily a question for the court to decide rather than this tribunal. The key issue which we will be relying on is a matter of legal principle, is that the English court has said that an arbitral tribunal has lacked the power to act effectively in relation to the preservation of assets when an order is required that would have the effect of binding third parties, which obviously a tribunal can't do, and or the tribunal's order would not be buttressed by sufficient sanctions. And obviously in the case of an English court injunction, you have the sanction of contempt of court. For the tribunal's note, I rely on paragraph 80 of Pacific Maritime Asia Limited and Holy Stone Overseas Limited, which you have in your bundle. So having orientated the tribunal through the legislative framework, I will now address the tribunal on each of the two issues in turn, and we'll start with the issue that we have just been discussing, which is, can Waystar invoke section 44 at all to apply for the English injunction it obtained? And the core issue here is whether the parties have excluded section 44 by the terms of their arbitration clause. Now, please could the tribunal turn up that clause, which is Judge Brower has just read, which you'll find in your information pack at paragraph 7 of the background facts. And it is the second sentence which the PGM shareholders rely on. None of the parties hereto, nor any persons claiming under any of them, shall bring any action or other legal proceedings against any other of them in respect of any such dispute until such dispute shall have been resolved and determined by the arbitral tribunal. The point that is taken against me is it is said that this excludes any application to a national court during the pendency of the arbitration. Now, that is an incorrect reading of this provision for at least 4 reasons. The first reason is that it's important to bear in mind that the arbitration clause in this particular instance is governed by New York law, not English law. The substantive law of the contract is New York law, and the arbitration is seated in New York. Therefore, the key question here is how the arbitration clause should be construed as a matter of New York law. And the English cases which Mr. Bishop relies on as point of construction are simply irrelevant. Second, the parties clearly intended that no court action is to be brought in relation to the substance of the dispute until the tribunal has first resolved the dispute. So to answer the question that is put, the way in which the second sentence ought to be construed is that it excludes court action in relation to the substance of the dispute and not ancillary proceedings which are there to support the tribunal's determination of the substance of the dispute.
Excuse me, counsel. The term I see here is in respect of any such dispute.
Yes, but it starts, none of the parties hereto, nor any persons claiming under any of them, shall bring any action or other legal proceedings or against any or other of them in respect of such dispute until such dispute shall have first been resolved. Yes. So the contractual submission point or construction point, and I do have New York case law which supports me on this, which I'll take the tribunal to in a moment, is that the proper commercial construction of that provision is that it is intended to deal with an action or substantive legal proceedings in relation to this dispute, and not ancillary proceedings which are intended to support the substantive resolution of the merits.
And that is how you understand the term in respect of any such dispute, that is confined to substantive claims?
You could read into this clause before dispute, substantive dispute, if you wanted to. That would be the only commercial construction of this particular provision. And as I'll show you in a moment, Professor Bermann, that is a similar approach was taken by the New York courts to a clause in similar terms. In fact, I would say less favourable terms. It is, in other words, the injunctive relief granted by the English court, which Waystar seeks the continuation of, is not contrary to the second sentence of this arbitration clause at all. The arbitration proceedings will finally settle the dispute. The English proceedings seek to maintain the status quo while that is achieved. The third point is that one needs to construe the arbitration clause as a whole. And incorporated into this particular arbitration clause are the ICC rules. Article 28.2 of the ICC rules expressly preserves the right to apply to a judicial authority for interim or conservatory measures in appropriate circumstances once the tribunal has been constituted. It would be worth, and I appreciate the tribunal doesn't have this language before them, but one could contrast Article 28.2, which relates to an application for interim relief before a court, from Article 28.1, which deals with circumstances in which a party can apply to the tribunal for interim relief. And the reason for contrasting those two provisions is Article 28.1, and only Article 28.1, begins unless the parties have otherwise agreed. And so what the ICC rules themselves contemplate is that there can be a party agreement to exclude interim measures applications for a tribunal, but on the face of them, the ICC rules do not contemplate an agreement between the parties to exclude applications to a court for interim measures. What is the significance of that? Well, I say the significance of that is that the tribunal has to construe this provision consistent with the ICC rules. And if a party wished to exclude an application to a national court for interim measures, you would need extremely clear language indeed. For example, a direct reference to the exclusion of Article 28.2 of the ICC rules. And of course, no such language is found in our clause. Fourth, I mentioned a moment ago that my arguments find support in New York law jurisprudence and in commentary generally, and I want to make that submission good. In Favorley Transport Malmo AB, the Southern District Court of New York held that an arbitration clause which provided that any dispute arising out of or in connection with this agreement shall be finally settled by arbitration without recourse to the courts. And the Southern District Court in New York found in that case that that language, which is in similar terms to our clause, did not exclude injunctive relief to preserve the status quo. It found further support for this interpretation because that particular clause, like our clause, also incorporated the ICC rules, which, as I've just mentioned a moment ago, preserves the right to apply to a national court. The Southern District Court decision in Favorley was upheld by the Second Circuit. It is, as in my submission, all fours with this case before the tribunal. And in fact, I would say that the Favorley arbitration clause is in stronger terms in terms of excluding an argument for excluding an application for interim relief to a national court than our arbitration clause, because it says without recourse to the courts as opposed to no action or other legal proceedings. The language in our clause, no action or other legal proceedings, tends, in my submission, to signal a claim in relation to the substantive dispute. Moreover, the distinguished author Bermann himself recognises in his Treaty on International Commercial Arbitration that courts that should not lightly conclude that a party is aggrieved to waive access to court-ordered provisional measures. And that page reference to his textbook for the tribunal's note is page 2744. So one should look for very clear language in my submission for exclusion of the right to apply to the national court, and it does not exist on our clause. In summary, on issue 1, the tribunal should not allow itself to be led down the wrong path by the PGM shareholders. New York law applies to the construction of the second sentence of our arbitration clause, and New York law would not exclude interim or ancillary relief application to a national court. I now turn to issue 2. Should the tribunal grant permission to Waystar to make the application to the English court? The answer to this, we say, is unequivocally yes. for the following 3 substantive reasons. First, as discussed a moment ago, the question the tribunal has to ask itself when considering whether to grant permission is whether there is a good arguable case that it will issue an award which will result in the transfer of shares or funds to Waystar. As a starting point, Waystar's breach of contract claim is a clear-cut one. It has paid its initial sum of $250 million US. It is therefore entitled on the clear terms of the PGM SBA to have the shares transferred to it. The only defence that the PGM shareholders advance to Waystar's claim is the alleged breach of warranty clause. This is hopeless, legally and factually, and certainly, in any view, is insufficient to show that Waystar does not meet the good arguable case threshold. Could the tribunal please turn up the relevant warranty provisions of the SPA, which we'll find in paragraph 4 of the background information. The tribunal will see that at clause 7.1, there is a generic warranty. But note, members of the tribunal, the relevant time period in this generic warranty. The question is whether the statements given at the time of entry into the SPA were true. Only the fundamental warranties, not those contained in Schedule 4, must be true at the completion date, which we accept has not happened yet, but it is irrelevant to us because the PGM shareholders rely on Schedule 4, Clause 8.6, as opposed to a fundamental warranty. So they must show that this statement, or the statement they rely on in Clause 8.6, was incorrect at the time of entry into the SPA. Clause 8.6 imposes several requirements on the PGM shareholders. They need to show, first, Waystar's knowledge at the time of the purchase. Second, the existence, and this is the most relevant part we say for present purposes, the existence of a material investigation or inquiry. And third, that this material investigation or inquiry would have a material adverse effect on any member of the acquiring group.
I miss something. I'm sorry, counsel. Did you say that the reference to fundamental warranties doesn't cover the warranty in this case?
That's my submission,
And
yes,
could
sir.
you elaborate on that?
Well, if you look at clause 7.1, it reads, the purchaser warrants to the seller that subject to the provisions of this agreement, as at the date of this agreement, each of the statements set out in Schedule 4 is true and accurate. And then pause there. And as at completion date, each of the fundamental warranties is true and accurate. So my submission, reading clause 7.1, which is the only provision we have, it draws a distinction between the Schedule 4 statements and fundamental warranties. And that's why I say we're not in fundamental warranties here, we're only in Schedule 4 of clause 8. Schedule 4, which is the statements.
And they're
I'm sorry.
mutually exclusive in your contention.
In my contention.
Excuse me, the fundamental warranties is capitalized.
Yes,
It suggests a definition
yes,
somewhere
yes.
that on the face of it may or may not include Schedule 4, Clause 8.c. On the straightforward language here, there is a serious issue, it seems to me, for argument as to whether or not the Schedule 4, Clause 8.c is a fundamental warranty. And if you, in addition, if you look at Schedule 4, acquiring group is a subject of any material investigation, inquiry, or enforcement proceedings or process by any governmental, administrative, or regulatory body. And I think you take the position that the fact New York Magazine said something about, well, there might be a problem, that falls within that.
Well, I think there are two issues here. One is, what is a fundamental warranty? And then the second issue is whether
Right,
or not the statement in Schedule 4 is met. taking the first point raised, which is whether or not there's a fundamental warranty, it is possible that I accept that there's a definition of fundamental warranty. We don't have that here. So my submissions are based on a construction of clause 7.1, which I've just made. But even if one were to construe Schedule 4, clause 8.6 as a fundamental warranty, it doesn't hurt my case in the slightest. Because what I'm now going to show you is why Schedule 4 is not met in any event. Schedule 4, clause 8.6 not met in any event.
Ms. Welsh, I know that we've had a few questions, but please be mindful of the time that we have.
Thank you. I'm coming to an end. So none of the requirements are met. All that has happened is that a newspaper, the New York Magazine, has printed an article alleging a cover-up of crimes. That's all that's happened. First, that article was not printed until after the SBA was entered into. We know this because the article was published after the 250 million initial payment was made by Waystar. Second, there is no evidence of a material investigation or inquiry. All there is a New York Magazine article. Third, there is no evidence that the directors of Waystar knew about the supposed cover-up or when they knew. Fourth, there is no evidence it will have any material adverse effect on any member of the Waystar group. In sum, the PGM shareholders' defence is all conjecture. Reliance on the New York Magazine article is nothing more than an excuse. The PGM shareholders simply wanted to bag their better deal with Malik and were prepared to breach the SPA to do that. The second overall point is that the SPA shareholders make is that they have limited opportunity to complete their deal with Malik. But they cannot sell those shares to Malik because they are contracted to sell their 75% shareholder to Waystar. And what's more, they're still sitting on the $250 million upfront payment. What this shows, if anything, is that the PGM shareholders are determined to transfer their shareholding to Malik. It is evidence of a real risk of dissipation in itself. Third, the ICC rules provide that once the tribunal is constituted, a party may apply to the court for interim relief in appropriate circumstances. There is no requirement under Article 28.2 of the ICC rules for the parties to have to seek permission from the tribunal before making that application. That only comes from Section 44.4. But even if it's relevant to the tribunal's discretion to consider whether an application to the court is appropriate in the circumstances, it clearly is in these circumstances for three reasons. First, it is appropriate for the English court to act. Relief is sought in relation to assets which are within the English jurisdiction, the PGM shares and the $250 million, which was paid into a UK bank account. In other words, the assets are subject to the jurisdiction of the English court. Second, the tribunal cannot grant effective relief in the circumstances of this case, and I say that, of course, with greatest respect to this particular eminent tribunal. It does not have the contempt jurisdiction, and its orders will not bind third parties, such as a registrar of the companies in relation to the PGM shares, or the bank holding the $250 million who've been made aware of the English injunction. Finally, the application to the English court does not undermine the arbitration process. The tribunal will still decide the substantive claim as a matter of New York law, applying New York procedure as agreed. But this will only be effective if the assets are there at the end of the day to enforce against it. This can be tested in this way. Assume an award is obtained in Waystar's favour, i.e. this tribunal orders the shares in an English registered company to be transferred, and there is non-compliance with that award. The only jurisdiction where one can go to enforce that award would be England and not New York. Therefore, to sum up, the answer to issue 2 is yes. The tribunal should exercise its discretion to grant permission to Waystar to apply to the English court. The PGM shareholders have already sought to escape their contractual obligations once by selling their shares to Malik. So what if the PGM shareholders end up with a financial liability to Waystar? That is their responsibility, and indeed it is a financial risk that the PMG shareholders, my submission, most likely factored into the Malik deal, given that it was agreed that Malik would pay twice as much for those shares. The tribunal cannot afford to risk the possibility that the PGM shareholders be given scope to evade any ultimate relief granted by this tribunal, restricting the parties to relief which could, to all intents and purposes, particularly with the counterparty we have here, easily ignored by the PGM shareholders in favour of their preferred Malik deal, notwithstanding the risk of liability to Waystar. I urge the tribunal to grant the permission sought.
Thank you very much, Ms. Welsh. Mr. Bishop, please.
Yes, Madam Chair. I'm Doak Bishop, and I represent the respondents, the PGM shareholders in this case. Now, whether I have much to work with, as Ms. Welch suggests I do not, I intend to do more with it than my learned opposition did in her argument. The first issue, and I will get right to it, is can Waystar invoke Section 44 of the English Arbitration Act to apply for a continuation of an English injunction that it obtained surreptitiously? Now, the parties' arbitration agreement, the relevant law, and the circumstances of this case compel a clear answer to the first issue before you, and that answer is certainly no. First and foremost, there is a fundamental obstacle to the granting of the injunction in this case, and that is that as a matter of English law, English courts have no jurisdiction to grant an injunction relating to this arbitration. This derives from two fundamental principles. First is the fundamental principle of party autonomy, what they have agreed to in their arbitration clause. And the second principle is that the natural forum for issuing any interim relief will be the courts of the seat of arbitration, which in this case is New York, not London. And after the arbitral tribunal is constituted, as it has been, then the natural forum for interim relief becomes you, this tribunal.
Excuse me, Mr. Bishop, is it your contention that authority to grant provisional relief is confined to the courts of the seat?
I'm saying that that is the natural forum and that this tribunal should confine it to the natural forum, which are the courts of New York.
And it's a
Now, I'm
natural
not saying that that English law necessarily agrees with that, but for this tribunal, that should be considered the natural forum, yes.
And the predicate of this is that only the so-called natural forum can afford provisional relief if it's not the seat.
Yes, that is
It
correct.
has exclusive competence to grant provisional relief.
It should have such exclusive power, yes.
But this is, this is a case which, when it was before the High Court, there was not some property to be protected in the United Kingdom. You're only dealing with rights in the abstract here and not with saving property or saving. Anyway, that's my.
Yes, we absolutely agree with that point that that the English law was not properly applied by the English court, and we will, I think, to that point, rest on that. But I have several other points I'd like to make.
Please do.
Now, Section 44 of the English Arbitration Act provides that an English court has jurisdiction to grant an interim injunction or to make orders relating to property which is the subject of the proceedings, only if the parties have not otherwise agreed, and only if the arbitral tribunal itself has no power to act or is unable for the time being to act effectively. In addition, where there is no urgency, an English court can act only if the tribunal gives permission for the court to act or the parties agree that the court may act. In this case, it is common ground between the parties that there is no urgency at this time, and the parties have not agreed to authorize the English court to act. Therefore, claimant must have this tribunal's permission to apply to the English court for an extension of the injunction. But there is a fundamental reason why, both why this injunction was legally infirm from its inception and also why it cannot be continued. As noted, Section 44 expressly provides that an English court may act only if the parties have not otherwise agreed. But in fact, the parties did agree otherwise in the last sentence of their arbitration clause. Now, you've already read it, but I want to emphasize it here. Neither party shall bring any action, or other legal proceedings against the other in respect of, and I think that the tribunal was quite right to point out those words, in respect of any such dispute until it has first been resolved and determined by the arbitral tribunal. Now, this sentence of the arbitration clause is referred to in the English courts as a Scott versus Avery clause, which prohibits the taking of any action or legal proceedings until an arbitral tribunal has determined the party's dispute. In other words, obtaining an award from this arbitral tribunal is a condition precedent to filing any form of action or legal proceedings in any court. Now, neither at the time the claimant sought and obtained this injunction and freezing order, nor at this time has the tribunal resolved and determined the party's dispute. No arbitral award exists in this case, and therefore the condition precedent for the claimant to be able to seek an injunction in English court fails. Now, this matter is clear not only as a result of the text of the arbitration agreement, but also as a result of English case law interpreting Section 44. In 2011, in the case of B versus S, this is the most recent English case on this particular point, the High Court of Justice in London construed an arbitration clause virtually identical to Section 38 of the SPA. The court expressly interpreted it as a Scott versus Avery clause, and the court held that on its true construction, the parties' agreement excluded the power of an English court to grant an interim injunction or a freezing order under Section 44. In that case, just as in this case, the claimant argued that the Scott versus Avery clause applied only to substantive disputes, not to ancillary disputes such as interim relief. But after exhaustively reviewing the history of the English case law, the High Court rejected that distinction and held that the clause should be given its clear meaning and effect. And that clear meaning and effect, according to the court, excludes any application for interim relief in the English courts until the arbitral tribunal has ruled. Now, there's a second major reason also why the English court does not have jurisdiction, and that is because under Section 44, the court has authority to grant interim relief only if the arbitral tribunal itself, and this is a fundamental point, only if the arbitral tribunal itself has no power to grant such interim relief, or if it's unable for the time being to act effectively. But once this tribunal was constituted and received the file from the ICC, then it was empowered under Article 28 of the ICC rules to issue interim relief. And the tribunal is able to exercise that power at any time upon application of either party. Put another way, this tribunal's lack of power to grant interim relief is a condition precedent to the English court's jurisdiction, but that condition fails. In the context of this case, the English court has no authority to renew the freezing order. I'm sorry.
Excuse me, counsel, wasn't the chronology here that the tribunal had not been formed at the time the injunction was first
That's correct. At the time this tribunal, at the time the English court acted without jurisdiction, this tribunal had not been formed.
Right.
Nevertheless, it acted despite the arbitration agreement between the parties. But that is correct on the on the chronology. Yes.
Counsel, I'd like to distinguish between the two measures of relief, the two provisional measures. One of them is, I believe, effectively addressed to wherever are located the assets that were to be frozen. And the second one was to restrain the PGM shareholders. Isn't there authority or jurisdiction with respect to the second one?
The second one, I'm sorry, being which one?
Interim injunction restraining the PGM shareholders.
I'm sorry, are you asking me if the English court had jurisdiction?
Yeah, I'm asking you whether there's any problem of jurisdiction for this tribunal.
Oh, for this tribunal, no, there is no jurisdictional issue for this tribunal, and there's no dispute about this. This tribunal has jurisdiction over the parties. We all accept that. And this tribunal has the power under Article 28 of the ICC rules to order any interim relief that it deems necessary. There is no issue about that.
Well, I don't know where these assets are located. Can you tell me where they are?
Well, the assets, there are $250 million in an English court, in an English bank, and then there are the shares.
Well, do we
But
have
the shares
authority?
themselves have no particular place of origin. They're shares.
Do we have authority to address an
Yes.
order to the bank?
Yes. Well, no. Well, you don't necessarily have jurisdiction over the bank, but you don't need it. We accept that you have jurisdiction over my client, and we will follow any orders. We'll give you an undertaking. We will follow any orders of this tribunal. So you don't need jurisdiction over any third parties, and that's not really in dispute, I don't think. If I may continue?
Yes, please.
Yes. Now, I want to go back to the point I was just making, and I want to be very clear about what I'm saying. What is required under English law is essentially a lack of power by this tribunal to grant interim relief, as we were just discussing. But that does not equate to a desire by this tribunal to either defer to an English court or delegate your jurisdiction to grant interim relief to an English court. An attempt to delegate that authority would not be effective, first of all, in the face of the parties' express agreement to the contrary. And in addition, it would be an abrogation of your jurisdiction and your responsibility for you to give up that responsibility to handle all issues in this case and allow a court to do it. And I also want to address another fundamental fallacy of my learned opposition. She says it makes no commercial sense to exclude resort to courts for interim relief. To the contrary, it makes perfect commercial sense to require that all issues be decided by the arbitrators who were selected by both parties, whether they're substantive issues or ancillary issues. Here, the parties have made clear that all issues were to be concentrated in the tribunal's hands, and that you, and only you, would be entrusted with deciding all disputes between the parties. Now, finally, with respect to the first issue, claimant refers to Article 28 of the ICC rules for the proposition that by agreeing to those rules, the parties agreed to have an English court rule on interim relief. That is not correct. Article 28(2) provides only that an application for interim relief to a competent judicial authority shall not be treated as a waiver of the arbitration agreement. It cannot be interpreted, however, as providing consent of the parties to a national court to grant interim relief, especially when the parties' arbitration agreement expressly decides otherwise. Moreover, Article 28(2) is temporally limited. It says expressly that it's limited to the time period before the file is transmitted to by the ICC to the tribunal, but that time is now passed. The tribunal has the ICC file in your possession, and you are the proper authority to decide on any request for interim relief. But there is no such request before you. The claimant has not put before you any request for you to decide interim relief. Therefore, at this point, you don't have the ability to do that, but only because there is no such request. Now, Article 28.2, I would note, also uses the words inappropriate circumstances even thereafter. But I suggest that when the parties have fully empowered this tribunal and you're constituted and fully functioning, and the parties have expressly excluded any action or legal proceeding in court, then there can be no appropriate circumstance for referring this matter to an English court. Now, if I may move to issue number 2, and I'll try to be brief on this, and that issue is, regardless of whether the English court has power, should you grant it permission to make the application to English court? Now, in light of the answer to the first issue, that Waystar cannot rely on Section 44, since the parties have excluded that power of the English court, and the answer to the second issue must, of course, be no. Since the English court does not have jurisdiction under English law, in fact, granting permission to it would be a futile act. But even if the court did possess such power, the answer would still be no as a matter of the proper exercise of this tribunal's discretion. Now, I've already discussed many of the reasons why the tribunal should, even as a matter of discretion, deny claimant's application, but there's still another reason. One of the requirements that claimants must prove in order to obtain an injunction is that it is likely to prevail on the merits. It's a matter of New York law. Now, my learned counsel on the other side vacillates here between applying New York law sometimes and English law sometimes, whenever it's most convenient for her case. And she suggests here that you should apply English law, despite the fact that the parties accepted New York law. But it is not the case that you should apply the good arguable case test. Since New York law applies, the New York test is most applicable. The claimant must prove that it's likely to prevail on the merits, and it simply cannot do that. And that is because of the warranties under Section 7.1 of the SBA and Clause 8.6 of Schedule 4. I won't go through the details of that. That's already been done. But I do want to come to the New York Magazine article. It's very important. It's now been published very quickly, very soon after the parties signed this agreement. And at the very time, it's very clear now that at the very time that the SPA was being negotiated and signed, Waystar was engaged in a massive cover-up of crimes that occurred within the Waystar organization, including widespread sexual assault, and we also believe crimes relating to the digital privacy of millions of people, as well as other crimes. Now, claimant denies any breach of warranty, and it's very important, I think, to note that the cover-up itself demonstrates awareness of the crimes. And it's inconceivable that a CEO and chairman as deeply involved in his companies and as controlling as Logan Roy would not have been aware of that cover-up. Now, claimant points to the specific wording of the warranty to argue that there was no governmental investigation or inquiry at material times. But in doing so, it overlooks the obvious fact that you cannot avoid the spirit and the legal import of the warranty if claimant was secretly engaged in a massive cover-up of criminal activity within its organization at the same time that it was negotiating with respondents and was hiding key information from them. To put it bluntly, claimant appears to have been engaged in illegal activity that it knew would necessarily lead to governmental inquiry and investigations with possible prosecutions and fines, and it failed to disclose that fact. That is a violation of the warranties, and as we get to the merits, we will show that. Now, the purpose of the warranty, yes,
Could I call
sorry.
your attention to part of the record you omitted to state. It continues, it is unclear whether Logan Roy and the board of Waystar Royco are aware of or possibly participated in this alleged cover-up. Call your attention also to the language in Schedule 4, Clause 8.6, which in capital initial caps refers to so far as the purchaser is aware, no member of the acquiring group, which appears to be a defined, I'm sorry, this, what do you do? Just push this or, okay. Acquiring group is a subject of any, et cetera, et cetera, et cetera. Who's in the acquiring group?
Well, we do not.
You're making an assumption about how things work, which they don't always, obviously, from cases we've read of other corporations.
I don't think I'm making some fundamental leap here, but we don't have the rest of the clause, unfortunately, before us, so I'm going to have to leave that point, especially in the interest of time, if you don't mind. I think, in fact, with that, in the interest of time, I'm going to close my initial argument so that we can get to the rebuttals. Thank you.
Thank you very much, Mr. Bishop. Ms. Welsh, we are running short on time. If we could make our rebuttals short.
Thank you, members of the tribunal. I'll try to be quick. The first point that Mr. Bishop raised is the question of the applicable law to the construction of the arbitration clause. The short point is that the B&S case does not help Mr. Bishop at all. It is a case which goes to the construction of an English-governed arbitration clause, not a New York-governed arbitration clause. I've already taken the tribunal to the Faverley case. It is relevant to note that there is also some textbook criticism of the B&S case, which is a first instance decision in the English court, and is being suggested by the well-respected authors of Merkin and Flannery on the Arbitration Act 1996 that the first instance judge got it wrong in the B&S decision. They argue that when Scott and Avery was decided in 1856, no one was thinking of a situation where a party would seek to commence any proceedings other than substantive court proceedings because interim relief mechanisms were not developed then. And they also argue that exclusion of interim relief is likely against the commercial interpretation of a contractual provision. And why is it against the commercial interpretation of contractual provision? Well, one can test it in this particular way. The tribunal has no power to issue injunctive relief over a third party. Imagine circumstances in where a party conspires with a third party in order to transfer assets out of the reach of the tribunal's jurisdiction or any orders which the tribunal could make. And those circumstances, in order to make the outcome of the arbitration proceedings effective, one necessarily needs to go to a national court. And that's why Mr. Bishop is wrong to suggest that my interpretation of the arbitration agreement is uncommercial. In fact, the absolute opposite is the case.
May I ask you, if we were to disagree with you about the arbitration agreement being limited to substantive, what would be the consequence in this case?
Well, if you
Does that not put an end to the case?
Well, I think I accepted in my opening submissions that if you're against me on issue 1, then that would
Okay.
that would mean that Section 44 is excluded.
Thank you. Thank you.
Mr. Bishop makes a series of false points in the ICC rules. They do expressly permit an application to a national court after the transmission of the file to the tribunal in appropriate circumstances and without advance of permission of the tribunal. I've already addressed that in my opening. Mr. Bishop's submissions in relation to issue 2, which go to the question of whether or not there is sufficient evidence for this tribunal to conclude on a good arguable case basis that that there has been a breach of the warranty, are completely hopeless. He puts no further evidence before this tribunal other than the New York magazine, which deals with and conjecture, is no substitute for proper witness evidence being put before this tribunal. In relation to the good arguable test case, Mr. Bishop wrongly submits that I vacillate on this. As the tribunal is well aware, when we're dealing with questions of international arbitration, it's quite often that two applicable laws will apply to a potential problem. I don't vacillate between English law and New York law on the test which the tribunal should apply to its exercise of whether to grant permission to this application. It's very clear. The starting point is, as a matter of English law, is there a good arguable case? Because that is the test for interim relief before the English court. And the answer to that question is a question of New York law, because the tribunal is assessing that on the basis of the merits in this particular claim. Finally, the important question which Judge Bauer raised, which is, I think it was suggested, I think this is fair to say, that what we're dealing here is not with assets, but abstract contractual rights. Mm-hmm. In my submission, that's a very important point, and it is not correct, in my respectful submission, to consider that what we're dealing with here is abstract contractual rights. Yes, what we're dealing with is a contractual dispute, and yes, what we're seeking to do is assess whether there has been a breach of contractual rights. But the interim relief goes to the effective preservation of assets so that once the tribunal has made its determination on the merits, there is assets which can be enforced against. And those assets are only within the English territorial jurisdiction, English shares and money which is in an English bank account. The reason why no application has been made to this tribunal is because, in our respectful submission, this tribunal is not able to act effectively in relation to those assets. What is required on the facts of this case, where the English court was satisfied that it was dissipation or a threat of dissipation of the 250 million, and where it appears that the PGM shareholders are determined to sell the shares to the Malik Group and have every interest in doing so, what is required is relief which has contempt jurisdiction back, so that third parties, which the tribunal does not have jurisdiction over, will ensure the money is not transferred out of the bank accounts, the banks, that the registrar of companies in England will not transfer the shares, and importantly, to the facts of our case, that the Malik Group will not engage in any underhand behaviour with the PGN shareholders. Those are my rebuttal submissions.
Thank you very much, Ms. Welsh. Mr. Bishop, your final remarks.
Madam Chair, I will try to be very brief in this rebuttal. I will address essentially two issues. Since my learned opposition did not brief the Favely case prior to this hearing, I am going to address it here in rebuttal instead of my main argument. She suggests that the New York Federal Court in the Favely case somehow rescues her arguments. It does not. The only issue you need to decide is whether you should permit an English court to decide the interim measures issue, not whether a New York court could theoretically do so under New York law. That issue has not been put before you because no one is seeking an injunction from a New York court, only from an English court. And the important point is this: While New York law allows New York courts to grant injunctions in aid of an arbitration, it does not and cannot grant jurisdiction to English courts to issue interim relief when English law itself does not authorize courts to exercise that power. Thus, New York law is simply irrelevant to an English court's jurisdiction to grant an injunction in the circumstances of this case. Now, there are also important distinctions between the Favely case and this case, but in the interest of time, I'm going to pass over those. The last point I want to make, and this is a key point, is that I want to come back to the two fundamental principles with which I began my argument. And that is party autonomy, that is what the parties themselves agreed to in their arbitration clause, is fundamental to this issue. And secondly, that the natural forum for granting interim measures at this stage is this tribunal. Both of those fundamental principles point to you, and only you, as having the proper jurisdiction to grant interim measures. Thus, for these reasons,
Mr. Bishop,
yes.
do we lack authority to endorse the English order? Can't we do that? Is that not at our?
Well, when you say, well, the word endorse, I
Well,
think,
let's say continue.
well, I don't think this tribunal can continue the English court injunction. You have the ability to make injunctions if a party applies to you, but no one has applied to you. And it's simply improper to delegate your authority when the parties have put all of the authority only in your hands. It's improper to delegate that authority to an English court.
If we had been requested,
Yes.
how would that change?
If you had been requested, then
say
you
we
would have
not been requested to do so.
then you would have full jurisdiction to decide what interim relief should be granted.
And could that relief take the form of allowing continuation of the English injunction?
No, because the English court itself did not have jurisdiction to grant that injunction. So the answer is no.
Well, let's take that point further. Indeed, if we do have the English injunction order, and now we have the case before us where we're only being asked on permission issue. But in fact, if we did have an application before us, couldn't we take into account, regardless of whether the order was within our jurisdiction, within our remit, couldn't we take that into account in making our own interim order?
You mean, could you take into account the English court's order?
Yes.
Well, I think you could take it into account in deciding what interim measures you might grant if you had an application before you, which you do not.
So taking that half a step back then, if we do, even if we accept that we have an arbitration, that we have party autonomy, that all of our remit is within our jurisdiction to make this decision, then what if there is no recourse to deal with a third party? What if, I accept that you don't think that a third party is engaged, but what if we were in a circumstance where we did think that a third party was engaged? What then do we have in terms of our power to deal with that?
So you're asking me another hypothetical situation of a situation that doesn't exist. Well, you still would not have the power to, you should not grant permission to go to the English court to deal with that when the English court doesn't have jurisdiction. It's as simple as that.
Well, I'm not sure exactly that it's hypothetical, and that, in fact, Ms. Welsh did indicate that there would be ramifications or implications of a third party, but I
Well-
accept that it is a bit of a stretch in terms of the facts of this case.
Well, I'm sorry that she's incorrect about that. But thank you.
Thank you very much. Thank you very much for your presentations. I know that we are running short on time, and so we can certainly have some deliberations here and maybe at the same time open up the floor for questions and answers, no?
Well, I was going to ask the question or make the point as the case may be. There's nothing that was subject to that injunction, which if the injunction did not exist, could not be cured by a final award of this tribunal in favor of whoever, because the damages would flow. And by the way, the record doesn't say that that $250 million is in a bank. It says that that company is busy very much in London and in Bermuda, and we don't know where it got put. But that's.
I asked that question.
Pardon?
I asked that question. Where it is? Where is it?
Well, so you got the answer. to the question. So you got the. You don't always get the correct answers when you're in class. Anyway, it's a very interesting case, but I think that the this warranty business is obviously for an evening like this, you can't create a complete record. I think we've experienced that before. So there are, some issues that you like it's in capital letters, it must be a defined term and so on and so forth. It's just sort of wordplay. We can't fill in the record, but it's a very interesting, very interesting case. Has anybody seen one like it? Or this one?
I think I
Somebody
probably had
goes off and gets
I think I probably had the downside of the second issue on the warranty, but I thought the argument was kind of interesting, trying to get beyond the words of the warranty and get to what the effect would be of the conduct.
Yeah, it was cleverly drafted. Whoever put it together was very cleverly drafted. It's a good show.
Okay, well, for me, it would be a very short deliberation because I think the arbitration agreement seals the deal, as you suggested it would if I read it the way I did. And I think that is the way a tribunal would read it.
You're in good company because Justice Flo, as he then was at the time, agreed with you. So,
Okay, so for me, this would have, there's an enormous number of fascinating issues that were raised, but that for me would have been determinative. The one thing I'd like to say is what I didn't hear very much about from either counsel was reference to a New York law on provisional relief, urgency, irreparable harm, a balancing of the equities. I actually just taught today, there are some students in the room, provisional measures.
yeah.
And it was all about this multi-factor approach. Is it urgent? Is there a more proportional remedy available? Is the harm suffered by the party seeking relief? Is it possibly outweighed by the harm if relief is granted?
Yeah.
I was just wondering why we didn't hear more about our own exercise of
Time.
Yeah, but I think this goes to the heart of one of the most interesting issues in the scenario, which is that we are applying to the tribunal for permission to make an application to the English Court for interim relief, right? So the ultimate body who will grant that interim relief is the English Court, and they will apply their own substantive law to that test. So the interesting question for me is, what is the discretionary criteria which applies to a tribunal sitting in particular sitting under a different applicable law when deciding whether to give permission? And so my argument was to say it's something less than deciding whether or not that relief should be granted, because whether that interim relief granted is a question for the English court. It's a softer assessment, and the reason why you have Section 44 there is because the English court does not want to step on the toes of the tribunal, and why not? Because the tribunal is assessing the merits. So the question that the tribunal really has to focus on is, what is its preliminary assessment of the merits of the claim which is being made? But there's no real case law on it. And what tends to happen actually on this particular provision, and the most paradigm case where you'll get interim relief of this nature is before the tribunal is constituted, where this doesn't come up. But what quite often happens is tribunals are actually very reluctant to say anything about the merits of the case at a preliminary stage.
Yes.
And so they will deliberate and may give permission, but the permission will say not very much at all. And actually that can be a source of frustration to the English court, because when you apply to make an application to the English court, they say, well, I can't judge the merits, the preliminary merits, because that's something for the tribunal to decide, but they've given me very little to go on here. So it's quite an interesting cross-jurisdictional point.
That's a problem that arises whenever preliminary relief is sought from a jurisdiction that isn't hearing the case.
Yeah.
And so, yeah, I quite agree.
I learned about a case yesterday, actually, in one of the events whereby I think it was silver dry bulk. I don't know if that came across.
That's exactly that Mail says in silver dry bulk.
Exactly. And
Tribunal should say more about it.
Exactly. And the point is that there is a lesser threshold that the tribunal has to look at. And so it's not necessarily something that the tribunal necessarily has to go into the merits deeply, but actually there is some sort of prejudging that is allowed, but not necessarily to the depth that, or the substantive kind of depth that we would otherwise do under an application for interim order. And in fact, the court ultimately said that in fact it's not so much that that the prejudging, that we would be making a decision that would then taint our subsequent decision on the same issue. So I think that there is something that kind of deals with that particular lesser threshold that we have on a request for this type of application. Are there any questions from the floor? I know we're keeping you from.
Time for a drink.
Almost. Not quite. You've got 5 minutes.
Okay.
Surely there is. Surely there is.
You got 5 minutes to educate us.
But surely there's a question.
Is-
Yes.
So I had a question, I guess two issues that seem to be lurking in the background that didn't come up. And one is this type of performance.
Yeah.
The interim relief was premised on the idea that the ultimate relief would be specific performance, but we didn't get into the question of whether there was a good arguable case for specific performance.
Yeah.
And the second part of the interim relief is effectively a security for costs application. We didn't get into those issues either. I'm wondering, obviously you had to choose given the limited time. Why didn't you get into those issues?
Well, I think the answer is the limited time. I mean, the first draft of my argument did have a few other issues in it, but then I timed it and decided I had to cut about half of it out. So I think that's the basic issue.
I mean, they're both good points. And on the second point, the sort of nature of the freezing relief in relation to the $250 million US. I mean, one thing that is slightly odd about it is that we are seeking specific performance of the transfer of the shares, and if they were transferred, then they would get to keep that $250 million. So that is a bit of an oddity, and I guess, I mean, we don't have enough facts, but one can only speculate that the reason for that is that it's unclear actually which way we're going. Potentially need the 250 back and might fly out of the jurisdiction, but it's a good point. It's a good unaddressed point. We can speculate further.
Oh, there you go.
You know, you said in your presentation, Ms. Welsh, that there wasn't urgency because the English courts had already covered you with the shield.
Yeah.
But if I understood from the past, that was going to expire in about a month's time. I just wonder whether that would, in and of itself, create urgency. Or if it wasn't urgent today,
Yeah.
would you then have urgency, say, 3 weeks from now?
But
And
then,
you wouldn't need permission from the tribunal?
well, the problem is, could you then have created the urgency by not applying to the tribunal until too late? And so I think probably the way to look at this is that the English court would expect you, if you had good time, to go to the tribunal under 44.4 and ask for permission. And only if the tribunal for some reason doesn't get round to it, or the other party's being obstructive, that you might get back into 44.3.
Claudia, did you have a question?
I was just curious whether there is a question of whether an exclusion of the party's right to go to a court for preliminary relief before the tribunal constitutes and whether that there's case law on that.
I don't know the answer to that, but I mean, what I think is very interesting about the ICC rules is that you can exclude interim relief from the tribunal, but on the face of it, you can't, by contractual agreement, exclude an application to a national court, though once a tribunal is constituted, it has to be appropriate circumstances. So it regulates it, but yes, I mean, possibly there is a point in that, and the ICC rules and their drafting might suggest that.
One last question. Doro.
Yeah, I was just intrigued. I was intrigued by the criteria that were applied to whether or not the tribunal should give permission to go to the state court. I mean, I totally understand that the tribunal would look at, does the arbitration agreement exclude it? Because obviously the tribunal has jurisdiction to rule on the arbitration agreement. It also makes sense to me that they would look at, the ICC rules and the requirements. Is it appropriate to go to a state court? And that would be probably driven by how effective would our order be? Could it be enforced? Where the bank account is, or et cetera, et cetera. Where I was really a bit puzzled was why the tribunal would actually decide whether there's a good and arguable case or likelihood of success. That for me goes to the substance of the injunction. And then if the tribunal starts kind of going into this, for me, that has the risk of really now two different entities or two different bodies deciding on the requirements of the injunction itself and kind of making it either harder, probably making it harder to get an injunction. But for me, my question was, is that something that's actually, that you thought, well, that is actually dictated by English law, that when there is a permission, if it were an English case, purely English, or an English tribunal, is there any guidance of what the tribunal should look at when it decides on whether to give permission? Would it actually really go into judging, is there an arguable case? Because that for me does so belong to what the court would look into rather than the tribunal.
Well, I think the English court would, particularly given, if you're into the permission process, I think, as I said, I think that's what the English court is looking to get from the tribunal, because it is the tribunal who will ultimately decide merits and therefore should make the preliminary assessment. But I think in your question, it seemed to me that there are two potential issues. There's one is the question of how much they should assess the merits, and there's how much they should go into other issues, as in broadly categorized as appropriate. So dissipation of assets or the appropriateness of the relief per se. And I'm not sure that that necessarily comes in at the permission stage, because that is something which the English court would have to decide within its jurisdiction. The other interesting point on that related to it is that 28.2 of the ICC rules, at least as I read it, says that you can only go in appropriate circumstances to a national court. But is the national court the one to decide whether it's appropriate for you to go, or is it the tribunal? There's no permission process in the ICC rules, so presumably the appropriateness goes to a test applied potentially by a national court. But that's I know that's not exactly what you asked, but on the facts of our case, I thought that's quite a sort of interesting subsidiary point, which separate to section 44.4.
Right, yeah.
Okay. Obviously, I want to pay homage to counsel. Just imagine arguing before this group. It takes courage, but that courage was well justified. I want everybody to know that counsel is not only responsible for the argumentation today, but they have to take full responsibility for the case, for having come up with the case. So if you were lacking information you needed, you didn't supply it. That's right. With that, I seriously mean that Every year we have spectacular advocacy. We have this time again. It's been 8 years, and without fail, we've had advocacy that we can only greatly admire, and we do. We do not yet know if we will convene in London or in New York next year. That will be decided soon enough. Why don't we go enjoy our company and some beverages? Thank you.